been referred for our consideration. Today's meeting is for members of the subcommittee to talk through issues that some of these bills present, so that they don't present. In the interim of our meeting last time and today, Ms. Benson has done yeoman's work in putting together a couple documents that are for you. We had concerns and questions about certain of the provisions in these bills that require constitutional amendment. Other matters that may or may not be considered constitutional if they go forward. And so there's a document for each of the members of the subcommittee that she has put together in that regard that we can talk through. The other document that she has done at our request, thank you very much, is go through these numerous bills and look at some of the overlap in them as to the issues that they address. And so that is Common Threads document that is before you. And then lastly, we have handed out a copy of S 1046 bill that was filed last week. The bill itself has not been referred to a subcommittee, but based on the contents of that bill in our discussion here today, I want everybody to have a copy of that in front of you. So with that, I'll open it up to members of the subcommittee to discuss any of the bills or provisions therein. The hope would be, as I stated last time, that as much as possible, we can come to some consensus on provisions to include in one bill moving forward. There are other bills, Senator Campson's bill, for example, S99 that deals just with a very limited aspect of this entire process. We could obviously consider that standalone, but as far as any consideration of what may or may not be changed regarding JMSC in that process, my hope would be that consensus. So with that, I'll open it to the subcommittee discussion. Mr. Chair, Senator Dahl.
So to the data I understand we have before us is what cannot be done under the Constitution in things that can be done under the Constitution. And other topics. So it's extensive. It's sort of hard to wrap your head around what bills we have. 16 bills. And so we have something before us that would say that all of these 16 bills, like each one that would have an issue, for example, like what cannot be done under the Constitution. We have these bills have some of these items in it, but the things that cannot be done.
So if you look, Senator, the question at this Common Threads document, Ms. Benson has broken down bills that would require an amendment to the Constitution to be enacted.
Okay.
And the bills there at the top, that's 178, 450, 872, 879 are all dealing with statutory changes regarding candidates that would not require constitutional amendment. And then she's broken it out, others that change the JMSC process that don't necessarily be involved in the Constitution.
So would on its face, then the bills that would require constitutional amendment, do we really think that we have muster in the body to amend the Constitution under this additional juncture into session and with the membership that we have in the Constitution?
I speaking personally, I would say no. Speaking more from just conversations that I've had with our colleagues, I think at least some have expressed a desire that statutory change could be enacted sooner rather than later instead of putting something on the ballot through that process and coming back later for ratification.
So, and so today we're gonna go through every one of these bills and find out the parts that we sort of like and not like it. Maybe then come back and try to see if we can find at least some general consensus amongst the committee. Going forward, we could end up having something that we can prepare for soon next week.
That would be my concern. And certainly open to have a meeting, and obviously there's a lot of material before us.
Chairman,
Yes, sir.
it's, you mentioned bills that would not require a constitutional amendment, and I think there's really not a list here that lists all those bills. I know mine doesn't require a constitutional. And so I think we ought to really, there are a few more. I think we ought to look at those because that has to be, or should be, structure. We ought to adopt that type of structure. I'm not saying you adopt mine, or there are a few others, I think, but I do think we need to, from a structural standpoint, focus on what can we do without having to amend the Constitution, because that certainly is the easiest path forward. And I'm not sure we really have that list, but we ought to be aware of that list and try to use that structural component, or one of those structural components, so we don't end up having to do a constitution. And if you can't accomplish the policy objective that you want, then you gotta make a decision. Is it worth trying to go for a constitutional amendment or not? But certainly it's best to adopt a form that does not require the constitutional amendment. I'm not sure what other bills don't, but there are others that don't require it. We're going to take all.
I think that's, I think that's fair, Senator Charleston. And it's a broad picture.
Mr. Chairman, excuse me. On the common threads document, the second category that has the joint resolutions, proposing bills, these are either joint resolutions or that bills that would require a constitutional amendment. That list of the 5 bills there, they would either be a constitutional amendment or would require constitutional for those 5.
So the rest of the bill, no.
The other bills, yeah, Mr. Chairman, there are some elements in the other bills. For example, if you seek to add requirements to what it takes to be a candidate for the Supreme Court, the Court of Appeals, and circuit courts by making limitations on family members, that adds a requirement that would require a constitutional amendment, because the requirements to become a circuit court, a Supreme Court, Court of Appeals, or circuit court judge are set out in the Constitution. So that's as far as we can go for those requirements. So any new requirements in any of these bills, and several of them have ones concerning family members that would require a constitution.
Well, I guess I'd like a list of bills that don't require. Right now, we can only discern it by the process of elimination. What we have before us, I would like to see a list of bills that don't require a constitutional amendment, because that's the lowest hanging fruit. In my view, if we can obtain our policy objectives in any of those forms, that's the best way to do it.
Mr. Chairman, I can tell you with certainty these 5 bills are going to require a constitutional amendment. I would need to go through the other bills as to where certain things are added in those other bills, as to whether, and particularly it's where the requirements for being elected to one of these constitutionally delineated offices.
Well, I think that would be worth doing, because we all know it's much better to do the statutory and constitutional amendment if we can. I just, those are the bills that I want to focus on. Make changes on margins. But that's what I think we should focus on.
Well, to that point,
Or I at least want to know, maybe everyone doesn't agree, but I want to know a list of ones that don't require.
that's another reason I asked that S 1046 we passed out. It's not technically, it should.
Yes.
As I stated earlier, that bill has not been referred. But it captures a lot of statutory changes. I read through this last night. I don't think there's anything in this particular proposal that would require a constitutional amendment. So if we can go through that, it captures a lot about appointments, number, makeup of commission, term limits. It does have a magistrate provision in there as well, which I personally, I don't think you can get in the magistrate part of the discussion. Subcommittee.
Chairman, as to the magistrate provision, the Constitution does not spell out the nomination process for magistrates. So I think technically, S 1046 would not require a constitutional amendment. But it is getting a little close because that is the process that has been followed for quite a period of time. It's similar to the issue of some of the bills would have a joint assembly where the election would have to be by a majority vote from the House and by a majority vote from the Senate. There's an Attorney General's opinion that has been issued that says basically for 200 years, joint public meeting, as the term is used in the Constitution, has meant a joint assembly where each member of the assembly has a single vote. And even though that we did have the case with Van der Linden that required weighted voting in some instances, that Attorney General's opinion specified that the process indeed was each member in the joint assembly has a single vote and not a weighted vote. The term joint assembly is not defined in the Constitution. I suppose one could offer a definition through the statute, but again, it is facing about 200 years of precedent.
Mr. Prince, is it fair to say that if we were to do away with judicial merit selection, that would be part?
That is correct, yes, sir. And if you did away with the General Assembly being involved in the creation of the Judicial Merit Selection Commission, that also would require a constitution.
Mr. Chair, do you think there's any will of this committee or any of our full committee or of the full Senate to get rid of JMSC?
I don't think so. Some have spoken to that.
And so it seems as though this late in the session, it wastes a lot of time thinking about that. So, or talking about it, and it seems as though that these bills, it's hard to get your head around. It may be something to consider. Take one, see what it's parameters, and then it would be easier to amend once you got to the floor and opposed to register this out because it's not in the Constitution. This is something that we know that go for. I mean, for example, I think that there's a lot of people that would say that they need to put more than 3 people out. And so when we start putting the process together, we'll say that, you know, if you got 6 qualified people, 5 qualified people, what the number is, and the body agrees on it, that's what they should be doing. And but you know, obviously there have been times that we has just been injustice to the fourth or fifth because there's similarly qualified. So, and then try to build from there. Understanding this great piece of work we have, piece of business, that we don't have a hard time putting it all together. It should take quite a minute to put it all together.
Yes, sir.
Chairman, I'm sort of persuaded by some of the comments of Senator Charles. I think to the extent that we've got 5 bills that clearly would require a constitutional amendment in order for us to do anything with that, my view would be that we would sit those to the side and then tackle the other. So that would be my suggestion.
Mr. Chair.
Yes, Senator Charles.
Might be a better question for Ms. Paula, but so this one sponsored by Senator Hembry, S1046. Is it comprehensive in that it takes into consideration all of the other bills that would not require a constitutional amendment, or there's some things left out?
Mr. Chairman, I believe there are a few things in some of the other bills that are not included in S 1046. For instance, I'm not sure that it includes the time extensions that Senator Hembry and Senator Timpson's bill S 99 includes, nor does it include the distinction that is made, I believe, in S 99 as opposed to pledging violations against the candidate. And in that bill, you extend it to the person as opposed to the candidate. So there are certain things that are not included. S 1046 does include many of the aspects that are in the other.
Are those the only, is Senator Timpson's bill the only
Those
one
are
you're
the ones
aware
that I think of right off the top of my head.
of? Well, I can see just looking at this, and I'm only on page 3 of Senator Hembry's bill, it doesn't have any provision for civil lawyers to be part of the JMSC. That makes zero sense to me as a civil lawyer. It's a harder area to look at, quite frankly.
Well, and I think to your point, Senator Charles, there are aspects of these bills that are supposed to shape. That's different proposals, situations worked out. Make a background of potential commission members. I know to say this is in there, but also standalone bill S 444. To the point that Senator Darlington made earlier, that bill on its own, all it deals with is removing the 3-person cap. Basically says that anyone with the commission that qualified would be so that bill, for instance, is in. Yes.
I'm trying to focus on large principles that can take various iterations. I'm totally open to the various iterations, but I think one principle is you don't want to do a constitutional amendment, sure. And frankly, I think another principle that is reflected in the bill I introduced, I know it's probably DOA, this aspect of it, but I think you can modify it. And that is, I do think, as y'all know, I'm a strong believer in the separation of powers doctrine. And separation of powers doctrine only works when you're playing at the same level of government, meaning that state government, the legislative, judicial, the executive branches, they are the competing interest where Madison talks about political ambition must counteract political ambition to keep branches in check. I like to say it's like, for those who know anything about coasting crabbing, it's like putting 3 crabs in a bucket. What happens when you do that? One crab starts to crawl out, the other 2 crabs grab them and pull them down. And so keep them from escaping. And so the separation of powers doctrine that empowers the legislative branch with power over the executive and judicial branch power over the executive, legislative, executive over the legislative, but in our structure, we don't have any real influence on the governor when it comes to the election of judges. And I think that's a failure of honoring the separation of powers doctrine. If you go to a different level of government, like solicitors, for example, you're not playing in the same sandbox. The separation of powers only works if it's all at the same level of government. Solicitors are elected by circuits. They're not part of state government. And so I think some way to let the governor have more of a say, and it may be just he makes or she makes more appointments to JMSC and less than the House and the Senate, probably is the only thing that could pass. But it's real important if you're going to have separation of powers doctrine that this political ambition that the framers set in motion that each branch would have the ambition or the incentive to keep the other two branches in check, that should come to play here. It should play at the federal level. The president nominates, the Senate confirms. And so we're leaving one branch, the state level, and that's the only level that matters. I mean, when it comes to county government or municipal government, no one worries about that around here. What you worry about is the governor going to veto what I just did? Or is the House going to amend my bill, or are they going to kill my bill? And or if my bill passes, is the state judiciary going to strike it down as unconstitutional? I mean, that's what you worry about, because you got to be playing in the same sandbox for the separation of powers to work. The solicitors aren't playing in the same sandbox. The governor is, but we're not giving the governor anything at all. But I know it'd be dead on arrival to give him something equal with us, but to have him have some play, maybe, appoint certain members of JMSC. But I think you're running afoul of conceptually what really is a reflection of separation of powers when you start adding locally elected officials, county officials, or circuit elected officials as picking appointees. And I think it really needs to be state level officials, people involved in state government. They're playing in the same sandbox. They're used to counteracting the ambitions of one branch in certain ways. But I think we need to look to that, I realize that I probably would give a little more power to the executive branch than others in the General Assembly would, but we can give them some and still keep
bills and we would designate that the Speaker of the House will serve on the committee or someone else, or Chairman of Ways and Means would serve on a certain committee. We don't do that. The other thing is that if we started going out and with something like this, for example, I use it because I don't think they did mention in any of this legislation, the indigent defense board, if you will, which comprise all the circuit defenders, the same as the solicitors and so forth. So then if they get an appointment, then we gotta reciprocate the one on the other side. And so when we get there, then when do we stop? When do we end up having the South Carolina defense lawyers or South Carolina claims lawyers or whatever? And so I just think that some of these things that have mentioning of various folks having a seat at the table on JMSC, and even with it being moved away from the building, seemingly problematic. And I just hope that when we come to something, that we stay within those parameters that you were speaking of. I hate to call on a name, but I had this long conversation with former President Pro Tempore, Lieutenant Governor Lynn McConnell, he was the architect of JMSC. And I just tell you, sometimes it's good to go back and try to get some wisdom about what to do and how to do it. He has some pretty strong and good opinions as to what should change, and if anyone care to, I would love for them to end up picking up the phone and calling them. And so I would start by saying no objections to, I think the word was used, to tweaking the MSC. What we have to figure out is that what we are fixing and what we're fixing that is could be perceived as wrong or depraved in some fashion. I think the one thing that a lot of folks agree on, but I think it's gonna be hard to carry out, is to get to the cap. The last time that we had a cap, the last time that we had a one contested race, I remember, I think it was the time whenever when Chief Justice Beatty and Chief Judge Hearn and Chief Judge Bruce Williams were running for the Supreme Court here. I think that was it. We went several rounds with just those three. And the question is that I think that there was wisdom beforehand, because I think there was some races a long time ago that took forever to end up getting a majority. And so we're in this climate that we're in now, where the General Assembly is in these factions. So there are certain groups that when, and it's incredible the background that you have to end up going through anyway to go through this process. Then to go back and check out the voting rolls, where these people voted and what primaries they voted in, then characterizing them. Then you're gonna set your block off. You set your block off and then cultivate and get to a final resolution if we get everybody to function. So will it cause a problem? Probably not, because then we got our chief justice, we end up putting judges to end up hearing cases if we get to that place where we can't make a decision. And so I think we got to consider this going forward. I mean, there's a lot of things I think that we fix in our system. I think the retirement is out of left field. I think the retirement of judges at 72. It's just bad for America in 2021. So what's the change to it? If 72 is wrong, then 75 is wrong. What do we do? So can we fix those things? We haven't. And so we're going forward with this now, fixing it. And we're having this difficult time. I'm having a difficult time because I don't know what we change it to. I think it's an imperfect system, but I think it's probably one of the best that we have, and the envy of a lot of folks around the country. And I do not have an objection to tweaking it. I do have an objection to breaking it.
Let's talk about one of the topics you mentioned. What is the will of them to the subcommittee as far as the cap issue is concerned? Stay the same, moved all together, is there a number greater than three? You know, I know in the past time in screening, I think we had 2 races that had 8 or 9. Right?
So, Mr. Chair, I think that whenever we leave this committee, if there's a recommendation, I think it's harder for us to make a recommendation here. I think that the recommendation is probably made on the floor, but I think we got to end up making it such that that is a that is a baseline issue. That's an issue we have to address, and I think that 46 folks on the floor will end up deciding that. We come in and say that we should lift it to everybody, or that we lift it to 6 or whatever. You know, it's gonna be a minute, so I think we just come up with a number here, we would add it in, say we open for it, see what the process is. Just make it such that we can have delineated discussions, and this is the issue that we address, right? The issues that we have.
I just recommend making it easy and going to 5, and then if anybody wants to amend it, at least this committee is doing something to move us forward.
Moving forward, what be Mr. Chair is to move the bill. And I think because moving in from 3 to 5, or from 3 to all. So we don't, I don't want to make a decision that changes things down. I know there's going to be a change.
I would like us to be able to identify the issues we address in a, I'll call it a work document. I agree. I think we all agree that whatever full committee, it's going to be subject to a lot of discussion and amendment. I think the same product that comes out of committee is about the same thing. That way on the floor. But I do think that the cap issue is something that our work should at least address. And discuss whether that number is 5. I think the next topic that the work document should address goes back to the point that Senator Charles and Senator Hanson is making, and that is what, if any, changes we discuss or look at as far as the makeup of the JMSC. I agree with your comments wholeheartedly about where any change should, I think, get into different groups. Personally, I'm not opposed to allow the governor to have some. My personal preference would be that member of the commission or any candidates the bill that we refer to 1046. One of the provisions allows the Chief Justice of the Supreme Court to have one. So I just throw that out there. I do think our work product will address makeup of the commission. What that may look like. So I think so. Discussion.
Mr. Chair, I'd like to consider, first of all, we have an even number. I don't know why we have an even number on the commission. That makes sense to me. Giving the governor an appointment, and then also giving the governor veto power with override power by the General Assembly. If he has a candidate that his appointee has been sitting in there and he absolutely disagrees with something, that again gives the executive branch a measure of control.
Mr. Chair, Senator Charles. Senator, veto power.
Over the candidate, yes. If for instance, the General Assembly appoints someone that the governor, for whatever reason, does not like, or even just within, it would need to be General Assembly is already approved of this candidate, and then if he has some bad heartburn over it, then he would be able to veto that candidate with the General Assembly being able to override.
For any candidate?
Yes. So to the extent then that would be considered unconstitutional, I would, withdraw that. I would try to give them a measure of some type of inclusion. And, I definitely think we need to have at least one more member or else we gotta back up and have fewer members so that we have an odd number of appointees.
Senator Henderson has put the governor into the process in a unique way.
Yeah, the bill, my bill as introduced has the governor's involvement in the sense that he nominates, candidates to enter into the JMSC process. And
He sends a single candidate back to JMSC.
correct,
After all the candidates file their paperwork with JMSC,
Right.
that's sent to the governor, who then sends a single candidate for each position.
correct. So, and then it's up to the JMSC and the governor, the executive branch has no involvement with the JMSC. And
But if they reject his candidate, then he has to sue.
that's correct. And this is what I think is good about that. Number one, really JMSC has up or down on whoever's nominated ultimately. And the General Assembly ultimately, if they pass through, that they're considered qualified. But also I do think that there are a lot of good lawyers, and I know some who are outstanding lawyers who would be willing to serve as a circuit court judge, just to give back. They've made all the money in the world they need to make, and just to give back to the legal system that they've been very successful in. But those people, they're not going to show up at the ramp for a month and a half
Or 5 months.
or 5 months and try to convince, like freshmen members of the General Assembly who haven't been exposed to this, who aren't involved in the legal system, why I make a good judge. And it also, and frankly, I think that the judges should be pretty much balanced between plaintiffs and defense attorneys by and large. I think that's where you get the best justice. And right now, it's really hard for someone who's a defense attorney who charges billable hours and not contingency fees to actually spend a month and a half, or what month are we on now? This term. I mean, it's like 3 months or something. So I think I think you would, like Senator from Darlington, you and I, when we were on the commission, we would look at, I think we were the first ones who really looked close at financial statements and answers on financial questions. And we had candidates who were 50-something years old, still paying student debt. We had candidates who didn't know the difference between about a death benefit and the value of a life insurance policy, a whole life policy, if you sold it or rescinded it. And so there was a lot of, so I'm thinking, these people are going to be standing over judgments over complex business issues, and they don't even know things like this. And so I really am concerned. And sometimes we have great candidates; they're just stellar. But I do think we get more qualified candidates if you didn't have to go through that initial process, and you would be including the executive branch. But it would be not as much power as the legislative branch has, for sure, but you are including that branch. And I think in the process, you would end up with candidates who are good lawyers who'd be willing to serve, but they're not willing to post up at the grant, going to the state house for 2 months, or they can't. And so that's how, in my bill, you keep the JMSC process in place. It doesn't require a constitutional amendment. And I'm not just pushing for my bill. I just want to explain thought behind what I did to include the governor. We can reject the governor's nominee and he or she have to produce someone else. And if you don't go for that, we can modify it somewhat, with presence on the commission itself. That's, anyway, I explained that. It's your suggestion.
I'll throw this out as well, so also I think it's a simple call at our last meeting that we talked about these proposals, preventing withdrawal of candidate. Frankly, at times, staff input to the candidates for the candidate's own benefit. You brought up the issue of financials. And I know that there have been times where folks come through and financials are all not accurate, et cetera, et cetera. And before that gets made public, just as common courtesy, somebody said, hey, look, you go through this process, here's what's gonna happen. And so, for those that say there's arm wrangling and all this other stuff going on in candidate withdrawals, I would push back hard on that and say that more times than not, it's for the person's own benefit. They don't get embarrassed for what they have had to submit that would become public. So,
Right, and just to add to that, we got to treat adults like adults. Those folks that are applying to be a judge, by and large, most of these folks are extremely well qualified. Some of them are just exceptional. It's unfortunate that we got folks that walk around every day practicing law that would be great judges that would go through the process. And so I think that whenever we are dealing with someone with kid gloves, they have an issue, I think that the best thing to do is deal with that situation head on and give them the opportunity. And for example, there are sometimes things that are uncovered during the process that they may not have been aware of themselves because we take ourselves not as harsh as some others can at times. That we got our own blind spots. And if you're gonna have a survey that comes in and says that majority of the bar thinks that your temperament is bad, then you don't want to go in and start having that aired out, try to explain your temperament. And they say, listen, you're gonna have a hard time. That's a decision you're gonna have to make. And I've seen the staff deal with folks, and it always end up with, this is message that we have. This is what is coming out. What do you think you want to do? And I can't tell you what to do. That's how it always is. And then so that point is that person make their own decision. But jump to another point. Just think about it. Going back in the 90s, this was happening. I was working for Senator City. I remember this JMSC starting out. I would come over and look at some of the hearings. I remember whenever they were coming up with the 10 Center for Charleston, and there was a big discussion during that time. And you know why it was put in there? Even numbers. To keep the House and the Senate. And we already know that the House is member rich and committee poor, which is the opposite. We are committee rich and member poor. And so 170 people, and a lot of times they're just saying that the number of people over in the House versus number of people in the Senate as far as getting elections. So the appointments came in, made it more equal. That's why it came up. I didn't say make it right.
But now we're talking about giving the governor a hand, so we don't need to make anything. I don't think I would submit it, but I'm also a little confused, Mr. Chair, because you brought up the fact that there's some allegations of harm twisting, I guess, to get candidates out while within JMSC. That's one issue. I thought that one of the bills I saw was once you are qualified and screened out, you're in it. And I do like that, even though I know you can't make, obviously, you don't want candidates to have to suck up and sit around the parking garage and all that kind of stuff. But at the same time, we have no female on the Supreme Court right now, and I think in part because they backed out and they had their arms twisted after they screamed out. So it just seems to me, if they don't want to come and hang out and they don't want to try and get votes or anything like that, that's one thing. But I'd like to see how members of the legislature repeatedly vote over time on minority candidates. With them backing out so easily, I'm not just talking about women, they're men, there are other minorities that sometimes do that. If they have to stay in it, I like the idea of then you can see how people have voted over the years, whether they have consistently refused to support a Black candidate or a female candidate.
Yeah, my comments were more certain people advocating for reform continue to point to prior races involving at times sitting judges and at times candidates. And that whole focus has been on withdrawing during the screening process. I think most of the bills, to your point, you're screened out. And you're one of the three as it's currently written, or whatever number it ends up being. At that point, you do what you want. But certain other proposals spoke that if you're a candidate going through screening, I just think that's a disservice. And chair, yeah.
Two subjects. First is just back on the bill I introduced that has lets the governor make nominees who go through the judicial JMSC process and then through the election. I think what we would turn South Carolina into the most robust advice and consent process in the nation, because if you look at what happens during JMSC, it is very robust, and there's no more critical look, I think, in the nation of candidates, judicial candidates, than our process. And the criticism of our process is, how do people get there? Why do they get there? Why do they get screened out? But if it's the governor nominate, we evaluate, we determine whether they're good or not. JMSC can kick them out. Governor got to send to someone else, and then you start having some conversations with the governor too about this is your problem. You got some leverage. The governor had some leverage, and you negotiate a little bit. But that's one thing. Really been advantageous. It'd be an extremely robust advice and consent process. The other thing is, I don't know how you tell someone with their own individual free will that you cannot resign from something that you thought you wanted to do. Then you realize, whatever reason, I don't want to. And we will make them stay. I mean, when I was on JMSC, we had some really difficult situations to deal with candidates. It cost me a lot of lost sleep. How do I manage this? How do I deal with this as chairman? When I was chairman, and it was in the best interest of the commission, best interest of the individual candidate, that he withdraw or she withdraw. I'm not even going to tell you who, the gender, but I don't know how you prohibit that. If someone realizes, hey, this may be a real embarrassment for me and it may affect the rest of my career, I may not make it as a judge, but I don't want it to ruin my career because I decided I wanted to try to become a judge and I made a little slip up. When you're dealing with the canons of judicial conduct, which judges, lawyers are familiar with their own canons of professional responsibility, but not the judicial. You're subject to that once you become a candidate. And if you unwittingly violate something like that, and that could ruin your legal career. You need to let someone like that, for example, and other examples as well. So, I'm not for this trying to thwart someone's desire to withdraw. So often that's usually in the best interest of the individual to withdraw, you know?
Yeah. Chairman, I would just say that the conversation that we're having here, really we're having because of all the conversations in the past. What has gone into creating what, in my opinion, is a good, solid institution. Less than perfect, but good and solid. And all of as I listened to the exchange between both senators from Charleston, not the first time that conversation's been had. It's been had in the past, but the result of it was it sort of ended up on the side of the senior senator from Charleston, where when you balance all of that out, the idea of a person being able to make his or her own decision as to what's in their best interest ultimately trumped all of the other wonderful considerations, like the idea of how does an individual vote, which is, in my mind, is a serious consideration because of the absence of diversity that we have and the dwindling level of diversity as it continues to slide. And I'm still trying to listen to folks and get an understanding as to where the real rubs are and what is that we can do to make the institution better. I agree. I think it's one of the finest tools that any state in the nation has when it comes to selecting judges. And when you look at performance of our judges, we don't have judges going to jail. A lot of what's happening in other states doesn't happen in South Carolina. I think it's due in large measure to the system that we have in place, as imperfect as she is. And so I would not be in favor of the idea of persons being restricted from making their own decision, role and those kinds of things for the various reasons that Senator from Charleston articulated. But Mr. Chairman, I think that we probably should continue with the bullet points and try to see what else we can agree on. Sounds like we agreed on two things so far. That is that an issue for consideration is the number of candidates. The other issue of consideration is the number of commissioners. Then a consideration as relates to who nominates how many persons on the commission. Should the governor be in the mix? And if so, as the junior senator from Charleston indicated, it's an opportunity to make it an uneven number as opposed to an even number. Does that mean we go up to 11, the governor getting one appointment, or do we strip one appointment from the House, one appointment from the Senate? The governor has 3 appointments, and the House has 4, and the Senate has 4, which gives us an even number of 11. And I think those are the issues that ultimately need to be decided by the 46.
I think you're right as to those two issues. You know what, one thing, Senator, I find interesting, to the point we all wrestle with, what are we trying to fix? Well, and so my thought on that is this. I know in certain of these proposals, it requires members of the commission to be members in good standing with the state law, which I agree. If the issue is that people who serve on the commission get favorable treatment when they appear in front of judges that they screen, I don't know that part of this legislation fixes that either. That criticism has always been to be out there from someone who doesn't like the result, doesn't like the person, or who lost the race. So I know right now that's sort of geared at legislators, but as I read it, if every member of the commission is a member in good standing of the bar, not all of them obviously appear in court. I would hope that the majority of those who are screening judges are lawyers that appear in court. Is that same argument going to be made then? That JMSC is all powerful, it's anything they want, it's not involved. I just throw that out there.
I've seen some, Mr. Chair, I heard one judge came before this body before he described it, the way I see it happen. 4 times than not, and the judge is now retired. Senator Charleston, I think you were there when we made this comment, said that we talk about fair and neutral on issues. And his testimony was, he said, well, you know, we're only human. And he said, there are times whenever we'll have some people that we see all the time, some friends and some others that we have to end up judging. They come before us. Says, now, I'll tell you how I act. Says, if I have a friend or someone that I know really well that comes before me and the issue can go one way or the other, that friend's in a lot of trouble. Because at the end of the day, they just call it both balls and strikes that they're looking for something else that happen. That's what a good judge does. But if they don't, and we see that that is a problem, there is a way to get rid of them. And it fits in their process, and that's what happens. We got the bar, the lawyers and the judges have the most strict disciplinary matters, disciplinary entities that there are, or strictly meaning the other ones that are around. And I've seen judges over here that really have been stripped down really badly in this process. And so as I look at this thing, sometimes we have to look at it and no one saying it out loud. Sometimes it's not just a process or JMSC, you know, have we dealt with personnel? How do we handle it? We can count the folks that did not make it through that are sitting judges and see what happened, see whether it was justified or not. And so are we fixing something that is broken? Or are we tapping on it just because of public perception?
Senator Charleston.
Public perception can a lot of times be reality. And I think what I'm hearing from most people is that we have too many lawyer legislators on JMSC. I think quite frankly, all members on JMSC should be lawyers and should have X years of experience, a high level of experience. But it's the lawyer legislature aspect that I think is causing public trust to erode. So I'm hoping we can maybe address that.
Jim. To sort of add to that though, in terms of the non-lawyer commissioners that I've had the pleasure of serving with, they also bring value, just from a different perspective. We're fortunate to have a former clerk of court.
You might soon be a senator.
But her perspective on certain things she picked up on that we did. So it's of value to the commission. So I just want to share that because it's part of my experience.
Mr. Yes.
Well, I'd like to address it. Particularly in the selection of appellate judges, Court of Appeals, it's very important that people in the commission know and understand the foundational legal principles of our nation. And you learn that by becoming a lawyer. And I screened judges running for the higher you know, the Court of Appeals, Supreme Court, who ask them questions that are basic, fundamental constitutional principles that if you're going to serve on the Supreme Court, you better know. And get a deer in the headlight look. And if I'm not a lawyer who understood the Constitution and understood the framers' vision and why they did what they did, I wouldn't even know to ask that question. But they don't know fundamental constitutional principles running for the Court of Appeals or they're running for the Supreme Court in the past. So who's going to ask those questions? There aren't lawyers on there to ask those questions who've studied it. I'm not saying they all have to be lawyers. I agree with Senator from Georgetown and Williamsburg, but the notion that you need to be ignorant of the law in order to ascertain who's going to be a good lawyer makes no sense whatsoever. The only question is, are you they just assume everyone's getting a good. I don't do a lot of litigation, but I've done some, and I've never got I've never treated better or any different than any other lawyer. South Carolina judges. But I think they go out of their way to make sure that they don't do that. I mean, it may happen on the odd chance, but you need to know how to screen. If you want to screen a judge, particularly an appellate judge, you better know. You need to know some of these founding principles that come into play in their courtroom. And if they don't know it, they should not be on. They should not be an appellate judge.
Let me throw this topic out. Senator Charles, your bill has and deals with seeking pledges / commitments, extends the time for doing so to the 12 days after. So JMSC report says that an election shall not be held for at least 22 days thereafter. What's the 7 days for that?
Can I say why? May I say why? I think it's way too soon for someone who didn't serve on JMSC and you want to digest all of this material about very important races. What ends up happening is those who want to actually elect judges on the basis of whether they're qualified to be judges, you have to study the JMSC report. For those who want to elect judges based upon, well, this judge is in my neighborhood. He's in my town. So those people are getting commitments right off the bat. And we all know who those people have been or have been. It's not about judicial philosophy, it's about parochialism. And so that's one of the biggest problems we have. The people who are just care about, is this person from my district, my county, my friend, I want to vote for them. They get a head start, but once they get the momentum of getting these commitments, and I'm sitting here studying, like when I was on JMSC, I didn't have to study because I went through the process, but not being on JMSC, I got to evaluate, this person versus that other person. And if you have 5 people or 10 people for each office, it's going to be even a lot more difficult. But I don't have time to study. And they've already won. The people who are just, some people care about geography. I care about philosophy. And caring about philosophy or judicial philosophy ought to be what carries the day. And therefore, those who want to evaluate that need more time before commitments can be made. That's really the reason behind that bill that I've introduced for the last 10 years, probably.
Sir, wait.
Chairman, I don't know that Senator Charleston's bill caught my attention before, but it caught my attention this time around. And I really think it's a good idea because races are over before they begin.
Yeah.
And literally, day after commitment, the races are over. And so I think he's on to something. I think that's definitely something that we can improve upon. Because a lot of our problems, not JMSC, quite frankly, is the body.
So Charles,
Is there any will to make it so that judicial candidates, first of all, they're not personal friends of ours, they not contact us on our cell phone or at our other business offices. But then also, why do we make them hang, I know they don't have to hang around, but it's so demeaning. I think that maybe could we just lower the number of days that they're even allowed to come up and approach us and hang out in the garage? If we're gonna be extending the time so that we can read, I don't wanna extend the time, but then have to suck up in parking garage.
yeah,
I've thought of that myself.
point taken, we had a discussion about that, I've talked with staff. I think part of the problem is, it's a public building, you know, and so we can't restrict who can come and who can't, and then do you say, okay, if you're running for judge, don't talk to members, then send that. I'm with you, but how we,
Can be discouraged,
Yes, they do.
and if they
Yeah.
come up and they're calling me on my cell phone and up here 24/7, I'm probably, even if they're from, I think most of the judges are from Greenville now, right? Certainly on the Supreme Court. I filed a bill, that didn't get referred yet, that if you're, in order to be a member. I didn't say Spartanburg, I said Greenville. Anyway, there's gotta be a way. I think that the candidates would appreciate it as well. They don't wanna be there.
I'm certainly open to how we accomplish that, confines of other laws. We obviously have to be cognizant of. But I don't have to make it.
Mr. Chairman, Mr. Chairman, we prohibit them from seeking commitments for a certain period of time up front. And perhaps you could do it on the back end too, if you have some limited amount of time. I mean, it's gonna be, but I agree that what Senator Charles was saying on that front, it's just, and you run people off who don't want to go through that. I think early on, I talked about some of the lawyers who I think would be great judges, who I know they've told me, but I'm not in that process. And if the process is short and abbreviated, kind of constrained, I can only be there so long.
What's the phrase? I'm not seeking a commitment yet, but
Appropriate time.
Appropriate
Yeah,
time.
Appropriate time, yeah.
yeah, do you do something regarding contact after you have filed as a candidate? Before it's done, maybe there's a way to put some contact
Yeah.
part there.
Yeah.
Especially if we're gonna let every candidate out that's qualified. We're gonna do that.
This past
I
time,
have to change myself in the,
this past time, there were 96 candidates, 38 seats. 77 of whom found qualified. And with the current cap of 58 were nominated, so there would have been 20 candidates. So it's there, I think you step out of where we're talking about the commitment time frame after releasing, which is, yes.
There was some discussion many years ago because we set the policy within the framework of the law that we had. And I remember we were talking about the candidate and changing it to no person. I see that you said that in your bill, and that's probably appropriate. I just think that whenever we and we continue to proceed cautiously, one thing that we have to do is say do no harm. We raised the pay for judges, and we got more candidates. We had one race one time that had more than 15 people in the race. We need to go back and see what the experts say and see what the story is saying now from this, that what happens whenever we get in a situation where we can't get a judge appointed and we getting an inordinate amount of time picking a judge. And I'm open to this cap issue. It seems like that line, because I've seen races where you can only have 3, and all of a sudden, you get 6 to 4 for one, and 5 to 5 for the other one, and then you get one person that's out that's obviously qualified but not nominated. So I think that the framework that we're putting together, I think the fact that people on the commission, the appointment process, things that we do on this time period that Senator Charleston had put together. I remember when we would have certain people in the General Assembly that were not lawyers, that on the day of visits, this race is over. I think that's unfair to that. I don't know about that length of time. Let's get started.
Two other things. Senator Darlington, you and I, when we served together on the commission, I can remember us commiserating when it came to the at-large circuit judge seats, that you would have one seat that has 3 just magnificent candidates. You can't hardly make a distinction between the 3. And then you have several at-large seats. There are no good candidates whatsoever. And I would like to actually be able to, assuming the candidates are willing, move them around to different at-large seats. I mean, it's, they're at large. It's not like you're always going to be in one particular courtroom. That ought to be something that we consider as well, because you and I commiserated over that at length, and it was more than just one seat. I mean, there were several seats that candidates were not up to par, and
Right.
and these other seats are like, why do we have all these stellar candidates and they're all running for the same at-large seat? So that's one thing I think we ought to do. The other thing I want to say, that something that similar to what the senator from Williamsburg stated about if you do let the governor have some appointment, and you came up with an 11, I think it was 11 person commission where the governor had some appointments. And I like what you said, I think, on first blush anyway, but that's like, would I rather have the governor just nominate them? Yeah, but do I think that's gonna happen? No. But I think something like what you articulated may happen. And that's the type of thing that I think could really make a difference in giving that co-equal branch some play, but it would not be dominant. But it would have some influence in the process. Maybe you could state that again.
And I'm happy to do that. Of course, I wasn't advocating for it, but.
Oh, I thought you were.
No, it wasn't. I really just kind of took the conversation that the 2 Senator Charleston. I was just listening to you all, and I know that there are issues worthy of consideration, but I'd be less than candid if I didn't say that I wasn't advocating for it. But the point that I made was Senator Charleston made a point about having an equal commission. Senator Darlington shared some historical information that it was so that both bodies have. So I thought if we were adding governor to the mix, it's an opportunity to have an unequal number. And do it by either increasing it by 1, go up to 11, with both of the House and Senate each still having 5 and the governor having 1, or you could stay at 11, take 1 away from the House, 1 away from the Senate. Governor would have 3, House would have 4, and the Senate would. That was just piecing together with all the time.
So I'm a little concerned because here we are 5 minutes until we need to be over across the street. And it's almost like we've been sitting around drinking coffee and coming up with great ideas. But we need to really start moving some of these ideas forward. We've not yet talked about term limits on JMSC. And I would like to at some point talk about mandated minority and female representation on JMSC. Women make up 37% of the South Carolina bar. Both law schools currently have, I think, one's 52%, one's 50%, 56% female law students. And we have 2 female members on JMSC, one of whom is not a lawyer. So I just think we also need to look at the diversity angles.
One thing, so I think the hope of this discussion has been good. I appreciate everybody participating as we identified the 4 areas in particular. If we can have staff work on putting something together, be a product that we can discuss further. So Charles and pare down, just volume that we have 16 deals. So you brought up term limits. That's a topic that's out there. Another topic that's out there that I'd like to discuss. Get into it today. And Spencer looked at this as well, but there have been some discussion about the actual conduct of the election. And is that something that continues to be 70 possible votes? Or is it something win a majority of both chambers to be elected? Nothing directly on point out there about that, but that's something that I know certainly.
Hey, is there a feeling of term limits for any legislator that gets appointed?
There is for me. I think we should discuss
Well,
it.
the thing is that, I think that the term limit for a legislator, that go to Judiciary Committee or Transportation Committee or.
Probably the appointees need to be, the ones who are doing it, I'm sorry, the appointers need to take into account once they've had somebody on for X amount of years, and that person needs to rotate off.
I have things out there, it's hard. But Mr. Chair,
On that point, real quick, if I may subtract that they're the non-legislative members.
Right, so I don't understand. I think 4 years may be short. How's Pete Strong been on there for that long?
Yeah.
No,
You got
okay. And reappointment, I think is, one thing, once you rotate it off, I mean, and you like the job and you want to try and come back in later. But I think that part of the perception problem here is the lawyer legislators that have been on the commission for a long time and rightly or wrongly have, ruffled some feathers and it's got the community thinking that our judges are not the best qualified candidates. And I disagree with that. I think we do have excellent qualified candidates, but it's a perception problem that we need to fix.
Mr. Chair, I have a recommendation with you. If I could, that we already put this framework together. And I think that in the essence of the community, that we probably get something going, something moving. And so if you could speak to each one of us and collectively put our ideas together, frame it up the best possible. Bill that you can based upon the information that you get from each one of us. They put together some framework for us here that they can look at next week and sort of put that in with some semblance of a bill. Because, in favor of what Senator Charleston said, is that we talk this is a conversation, but now we got to get a tool that can get us provided on the way something to bill. So I think that if you're gonna say, well, I'll talk to so and so, there's number of people on the committee. And this is what we talk about as far as the gaps, and then talk to each one of us and give them this best that we probably want to staff we ever had. Putting somewhere together for a bill for us to take a look at, report it out and get it out.
Sure. No, I won't take it. That's what we do. I'll get document together with absolutely no fraud of authorship that everybody can look at it and give us work from the topics that we discussed today. Certainly the others.
And also do want to see if we have a chance to do a little research, just in case we start getting to the floor. I don't know. If we had a thought in this news and else, whether we had the investigation along with delegation, if we have get to a point of having anyone come up with the idea of having legislators on the committee or not.
Anything else? Members?
We can receive the next call with the chair.